Zia v. Scott, out of the Eighth Circuit, actually starts at the district court level. It's about the Hague Act of the Hague Adoption Act, and so it's not a case we ever talk about on the podcast, yours or mine. But it's very interesting. Miss Zia is the biological aunt and adopted mother of her son Tim, her adopted son Tim. His parents got an EB-5 approved from China. Quite frankly, it was taking too long, and they wanted Tim to get his feet wet in America. And then when they figured it was taking so long, the record at least shows, they said, you know what, why don't you stay? He comes on a tourist visa, stays with his aunt, and then unsure how long the EB-5 was going to take to get to America for the parents, and with him already having been established in America, they had his aunt adopt him. They actually ended up coming a few months later. Their priority date was current, and but the aunt, but Tim stays living with the aunt for a couple of years, and the record shows she's quite in his life. But I mean, USCIS hated this, because by this point, now Tim is in a worse off position. He can't benefit from his parents' EB-5 process. His only way to adjust is through adoption, I-130. But China is a party to the Hague Act, and so you have to comply with the Hague Act conventions on adoptions or show why you can't. And USCIS said, no, you can't do this, and by the way, this all smells like they were trying to circumvent the Hague Act. You can't do that. You can't just pretextually send a child to America to get him adopted and not comply with the Hague Act convention and all the steps that have to happen there. Can't do that. The question became, was Tim habitually residing in the United States at the time of his adoption, which was I can't recall, maybe 6 months later or a year later. I think it was about a year later. USCIS said no. Our firm took the case, Ed Ramos and John Pratt. We got it sent back in this case, Zia v. Scott. So a little shameless self-promotion, but it's a precedential decision.
Nice.
And it's under the Administrative Procedures Act, like the all-powerful APA, which is what is doing so much work right now. I'm not sure if Congress in the 40s or the 50s, whenever the APA was issued, knew it would be doing so much work, but both under Biden and under Trump 1 and now Trump 2, the APA is the crux of so much of this litigation, and here as well. The agency, USCIS, is not just they can't just ignore evidence. They can't just say all of these things are happening, that he's attending school, participating in religious and extracurricular activities, and then not explain why that doesn't show that he was habitually residing in America at the time of his adoption.